Okay, you guys, welcome back to the channel. We have Attorney Steele has filed a supplement to motion to recusal Judge Glanville, and he also included some other information to go after the prosecuting team. So this is him going after that ex parte that we read the other week. So let's get into it. It starts off here, supplement to motion to recuse Judge Glanville. Then it has those notes, 1, 2, and 3. Okay, let's go down and read the notes, and then we will get into this. The motion applies to Lawyer Love and Hilton, in addition to Judge Glanville, as all three are material witnesses in the case's bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. This motion also timely moves to recuse the Honorable Judge Cross, based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April, Judge Glanville contributed $2,000 to the Honorable Judge Cross re-election campaign. Also in April, the Honorable Judge Cross donated $500 to Judge Glanville re-election campaign. And it states that Mr. Williams' trial has been going on since January. Let's go down. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25.1 if it is filed within 5 days after the applicant first learned of the alleged grounds for disqualification, including Saturdays and Sundays. This supplement motion to recuse is timely filed as the additional reason for this recusal were first learned Monday, July the 1st, when Judge Glanville permitted the court reporter to release the undersigned counsel the transcripts of the Monday, June 10th, ex parte meeting between Judge Glanville, Lawyer Hilton, and Love, the Honorable Attorney Bumpus, and her client, sworn witness Mr. Kenneth Copeland, and others. This timely filed supplement to motion to recuse has also been timely presented to the Honorable Judge Cross and Judge Glanville on Monday, July the 8th. Judge Glanville is swinging in the air. In the case at bar, Judge Glanville ex parte communications with a sworn witness, his counsel, Lawyer Love, and Hilton, and other representatives with the Fulton County District Attorney Office are seemingly only partial captured by the court reporter. He is saying that we didn't get the whole thing, y'all. Okay, let's keep going. Judge Glanville, Lawyer Love, and Lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply, as Judge Glanville has not acted as a judge, but morphed into a central part of the prosecution team. The judge conduct, including ex parte communications with the prosecutor during trial, resulted in the appearance of bias, recurring reversal of the convictions and sentence. Okay, we're on 4. Mandates that judges should neither initiate nor consider ex parte communications by interested parties or other attorney concerning a pending or impending proceeding. Yet, Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privilege and describing the improper sources as scarcent. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Mr. Williams timely raised his objection to this ex parte communication refusal of Judge Glanville, to wit, when he first learned of same. Trial transcripts dated June the 10th. Okay. And then it gives out a rule that forbids a judge from considering ex parte communications, as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his views that the communication at this ex parte hearing were privileged. Attached hereto order of contempt and incarceration for Brian Steele filed on June the 10th. Judge shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultation with experts or court personnel, and settlement conferences. It is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by affirmative showing that the judge did not consider this communication, and is given these things here. In the case at bar, there is not essential of evidence to overcome the presumption that these impermissible, illegal, unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. Let me move this up here. Thus, Mr. Williams' case should be reversed on direct appeal if there is any. Conviction and sentence. Ex parte letters sent to judge by witnesses was not harmful error where the parties asserted the error did not argue that the judge responded in any manner or gave the letter any consideration, as shown in the joint affidavit attached hereto as Exhibit A. Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District Attorney Office, as he dispensed legal advice and supported lawyers Hilton and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. Okay. In light of this ex parte proceeding, it is impossible to conclude the Judge Glanville is impartial and not a member of the prosecution team. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or party's lawyer or personal knowledge of disputed inventory facts concerning the proceeding code of judicial conduct rule 2.11. Judge Glanville has been dissolute in his judicial duties and must be recused. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th, an open court lawyer, Hilton and Love, sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced to undersigned counsel to the longest possible time in jail for unmasking Judge Glanville, Lawyer Love, and Lawyer Hilton improper, illegal, unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams' case. The reference section of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it is the judge's duty to disqualify himself as soon as he is aware that the grounds exist, which provides that no justice, judge, or magistrate shall accept from the parties to the proceeding a waiver of any ground for disqualification, including cases in which the judge has personal knowledge of disputed inventory facts concerning the proceeding. This includes ex parte communications. And then go down, we're on number 10, because it's just giving cases there after that. Let me move it up a little bit. In the case at hand, the state cannot show that Judge Glanville, Lawyer Love, and or Lawyer Hilton intentionally and willfully complicity in this ex parte communication was harmless error, as shown in Exhibit B. The improper influence and interjections by Judge Glanville and his two cohorts for the Fulton County District Attorney Office on Mr. Copeland's changed Mr. Copeland's stance not to testify against Mr. Williams. Mr. Copeland refused to testify. All of his prior false statements as to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation, intimidation tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, Lawyer Love, and Lawyer Hilton, resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at his trial. Moreover, ex parte communications are so disfavorable and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trials, same would not be harmless error because the ex parte communications are presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville, Lawyer Love, and Lawyer Hilton improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, the censure, and the silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials simply strolled into the courtroom, faced the cameras, called for the jury, and finished to continue trial as if nothing out of the ordinary occurred just hours, minutes before. Mr. Williams needs to examine Judge Glanville, Lawyer Hilton, Lawyer Love, and all the other members of their prosecution team to reveal the dates and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. The subject of same in order, the court reported to produce any transcripts of same and or unseal all documents from this potential improper ex parte communication. Undersigned counsel needs to cross-examine all of these parties to assure that the sworn testimony is spread in open court on the record. I know the other day, Little Woody, that Bumpus, she asked Little Woody, was the ex parte, was everything in there? And he said no. So yeah. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton, all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualifying from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified for Mr. Williams' trial, and the Fulton County District Attorney Office must be investigated for their improper conduct, if any, outside of the action of Lawyer Love and Lawyer Hilton. Bam! He going after the whole darn. Don't play with Steele. You come for him. Oh, he coming. He playing chess, y'all. Okay, 14. Judges must scrupulously avoid improper ex parte communications whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte in any time the judge is aware of grounds to do so. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that helping Lawyer Love and Lawyer Hilton to influence Mr. Copeland to change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself at the behest and encouragement of Lori Love and Hilton to ally himself with the prosecutors in this case. Judge Glanville's misconduct should not stand. The law must be, let's move it on down, y'all, followed. Judge Glanville must be recused and disqualified from Mr. Williams' case and Stanter. No hearing is actually needed to reach the findings that recusal of Judge Glanville and Stanter is mandated. Judge Glanville has automatically caused his recusal and disqualifications from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuted affluent allegations of judicial bias. If this honorable court disagrees, Mr. Williams respectfully requests a hearing as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witness to fully unmask this above discussed misconduct as well as further misconduct they may have. He's not playing with them. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County Court, the Fulton County District Attorney Office, and stands court throughout the state of Georgia and our country. What occurred in this star chamber outside of the view of the cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public is unpardonable, and all of his violations of Mr. Williams' constitutional right stated herein as well as in Exhibit A. Judge Glanville, Lawyer Love, Lawyer Hilton have created secret star chamber proceedings which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly, or system adheres star chamber proceedings with good reasons. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside of the lens of the cameras. These public officials should never be trusted by Mr. Williams or undersigned counsel. These are serious consequences for these intentional and unjustified misdeeds. They have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least appearance that Judge Glanville is not impartial. Judge Glanville must be removed, disqualified, and standard from Mr. Williams' case. As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Lawyer Hilton conspired to conceal and suppress evidence. This star chamber cannot prohibit Brady evidence from coming forward. That is exactly what Judge Glanville, Lawyer Love, and Lawyer Hilton plan to do. Mr. Williams' constitutional right to due process, a fair tribunal, and a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for the statement of a sworn witness have been violated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. June the 10th, Star Chamber meeting between Judge Glanville and Lawyer Love and Hilton undermined the public's faith in the integrity of the justice system as it is concealed from the public. Mr. Williams, his lawyers, and the other faces the removal of their liberty crucial information about the lawfulness and the reality of how they are being prosecuted. This injustice must end today. This trial is woefully broken and cannot ever be repaired, based solely upon the improper conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper action of the supposed judge and the state actors. He calling them actors. He ain't calling them lawyers or prosecutors. Okay. Judge Glanville At the Dr. Star Chambers ex parte meeting, provided legal advice and directed to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper grounds for the granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there is actual bias, as Judge Glanville has been embroiled in this trial, and in insisting the prosecution to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed based upon the one ex parte communication that has come to light. Thus far, Judge Glanville, lawyer Love, and Hilton have infected the process of Mr. Williams' trial and have illegally poisoned same forever. Judge Glanville had the ethical duty to recuse himself son spate once he had the ex parte communications. However, neither Judge Glanville, lawyer Love, nor lawyer Hilton uttered a word that they spent the morning of June the 10th leaning on Mr. Copeland to testify for the prosecution against Mr. Williams, coaching Attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify at trial against Mr. Williams, coaching Mr. Copeland on how to deliver his testimony, and promising Mr. Copeland that he would not be prosecuted even for purge testimony unless he told a bold-faced whopper lie. These public officials heard and failed to reveal that Mr. Copeland refused to committing every indicted offense in this case. Even non-lawyers can see that Judge Glanville, lawyer Love, and lawyer Hilton are not acting in ethical matters, are on the same, move it up, prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, lawyer Love, and lawyer Hilton have made themselves witnesses whom Mr. Williams' counsel will call. These three lawyers must be recused and removed from this case. Wow. It is important to note that Judge Glanville originally denied Mr. Williams' request for access to the June 10th ex parte hearing transcripts, keeping content of the records totally hidden by lawyer Love, lawyer Hilton, and Judge Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violation, and potential criminal conduct, by lawyer Love, lawyer Hilton, and Judge Glanville worked to effect change. On Monday, June the 17th, Judge Glanville denied undersigned counsel motion to recuse and went forward with the trial of this case. Similarly, Judge Glanville denied the Honorable Douglas Weinstein motion to recuse on June 12th. Judge Glanville then continued to unlawfully proceed over Mr. Williams' jury trial. Judge Glanville must be removed as he has proven to have actual bias as well as the appearance of bias. Yeah. Undersigned counsel has never been afforded the question that lawyer Hilton and or lawyer Love created and gave to Mr. Copeland. Undersigned counsel has never been given the list of questions, even though Judge Glanville has made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. Specifically, the question must be asked why Judge Glanville has ex parte access to lawyer Hilton and lawyer Love questions for a witness. This conduct is beyond repair. Judge Glanville, lawyer Hilton, and lawyer Love did not give hint that they were meeting ex parte with witness Copeland on the morning of Monday the 10th, June the 10th, or at any time. Undersigned counsel had no idea that Judge Glanville, lawyer Love, and lawyer Hilton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Judge Glanville and Lawyer Love and Hilton were duty-bound to immediately announce to Mr. Williams, his counsel, and all accused and their counsel that this ex parte meeting occurred. Brady and Gigolo evidence was obtained, and that transcripts was made, and allowed argument to flow. Instead, their cover-up equaled their misdeeds. Judge Glanville, Lawyer Love, and Hilton acted in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting unethical conduct and witness intimidation by deflecting the focus on how undersigned counsel learned of the secret proceedings. Judge Glanville held undersigned counsel in contempt of court. This misconduct by Judge Glanville, Lawyer Love, and Lawyer Hilton undermines trust in judges and prosecutors, cannot stand in and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. The conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville can never be forgiven, normalized, or ratified. Okay, let's move it up. The Georgia courts have always safeguarded and separated prosecutors and their duties from judges and their duties. Here, there is no daylight between Judge Glanville and Lawyer Hilton and Love, improper and unethical conduct. All must be removed from Mr. Williams' case. As stated herein, Mr. Williams intended to call Judge Glanville as a witness at trial, as well as this recusal motion, evidentiary hearing based upon his improper conduct and the need to make a further recorded to protect Mr. Williams' constitutional right. Specifically, there appeared to be communications not captured on the script of the June 10th ex parte meeting. Lawyer Love and Hilton and Judge Glanville examinations are needed to complete those records. Judge Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when undersigned counsel cross-examines Mr. Copeland when asked questions. Whether Judge Glanville pursued Mr. Copeland to testify, whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him, the fact that Judge Glanville condoned Mr. Copeland lying under oath unless it was a bold-faced whopper. Wow, this is deep, y'all. This is really deep. They messed up. Okay. The mandates that Judge Glanville not be in the courtroom in front of Mr. Williams' jury ever again as judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including, but not limited to, instance where the judge is likely to be a material witness in the proceeding. Grounds for recusal are contained, as well as the Georgia Code of Judicial Conduct. Further, the judge should be disqualified for bias against the party if such bias stems from an extrajudicial source and results in an opinion on the merits of some bias other than what the judge learned from his participation in the case. The alleged bias of the judge must be of such a nature and intensity to prevent Mr. Williams from obtaining a trial uninfluenced by the judge's bias. In the case at bar, it is impossible to honestly find that Judge Glanville is an impartial, fair jurist. Recusal is mandated. Let's see here. A judge must avoid all impropriety as well as the appearance of impropriety. Judges shall disqualify themselves from proceedings in which their impropriety might reasonably be questioned. The fact that Judge Glanville impartially might reasonably be questioned is grounds to mandate that he is removed from this case. Okay, Rule 2.11 provides an additional rule of disqualification that's broader than our statute. Here, under any definition in any rule, Judge Glanville must be removed and stand from the position of judge. In fact, Commentary 2 to Rule 2.11 explains that judges are subject to disqualification whenever their impartiality might reasonably be questioned. judges should disclose on the record information that the court believes the parties or their lawyers might consider relevant to the questions of disqualification, even if the judge believes there is no legal bias for disqualification. Impartiality might reasonably be questioned means a reasonable perception of lack of impartiality by the judge held by a fair-minded impartial person based upon objective facts or reasonable in reference. Recusal on the ground requires a rational bias for such questioning, not an arbitrary bias, even though no actual impropriety on the part of the judge has been shown. Judge Glanville's impartiality under this definition has been satisfied. And conduct mandates that the judge step down from proceeding over a case where the judge is likely to be a real and unessential witness and where there is not substantially the same testimony available from another witness. Judge Glanville must leave Mr. Williams' case, except for when he is called to testify as a witness to explain under questioning his misconduct and bias before the jury. The bias of Judge Glanville is of such a nature, intensity to prevent Mr. Williams from attaining a trial free from Judge Glanville bias and prejudice. And prejudice, bias, or prejudgment, or even exhibited partisan feelings and present in Mr. Williams' case and Judge Glanville must be removed. Mr. Williams asks this honorable court to hold an evidentiary hearing on this motion to recuse in order for Mr. Williams to gain a full understanding of this misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville throughout this case. Judge Glanville is so involved in this controversy that his objectivity can reasonably be questioned, and he must be removed as the judge over Mr. Williams' jury trial. The facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutor Love and Hilton from the truth of their misconduct, denied Mr. Williams' June 17 motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse, dated Monday, June 17. This demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. Okay. Significantly, Judge Glanville is required to avoid not just improprieties, but the appearance of improprieties in this activity. This is because public confidence in and respect for the judicial or courts must be maintained. Okay, let's see. The shocking conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville proves that bias and prejudice have been shown and would be error for Judge Glanville to continue on Mr. Williams' case. It has been held to be elementary that a judge must be disqualified if he is going to be a witness in the same proceeding. In the case of Judge Glanville has taken on the prosecutorial role against Mr. Williams and hence must be recused. These circumstances illustrate perfectly the inescapable conclusion that Judge Glanville is partial to the prosecution and biased against Mr. Williams. Judge Glanville attempted to cover up his and Lawyer Love and Lawyer Hilton misconduct by attempting to intimidate undersigned counsel and then holding undersigned counsel in contempt of court, sentencing undersigned counsel to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibility. Judge Glanville then took action before the jury after recusal motion were timely filed by the Honorable Douglas Weinstein as well as undersigned counsel. All of these actions taken by Judge Glanville after these writ and valid recusal motions were filed are void. Judge Glanville has caused Mr. Williams immeasurable suffering and prejudice bias upon his Lawyer Love and Lawyer Hilton denial of Mr. Williams' statutory and constitutional rights stated herein. Mr. Williams must be granted a reasonable bond, Mr. Williams' statutory rights to speedy trial has been totally unimpeded by lawyer Love, lawyer Hilton, and Judge Glanville, and Mr. Williams must be cleared of all baseless charges. As spelled out above, this supplemental motion to recuse is timely filed as same as filed, not later than 5 days after undersigned counsel, affluent for first learn of this additional ground. For disqualification to wit on Monday, July the 1st, when the ex parte transcript was first revealed to undersigned counsel. The attached joint affidavit, memorized as Exhibit A, supports this recusal motion by giving fair support to the charge that Judge Glanville's bent of mind may prevent or impede impartiality as required for Judge Glanville to preside over this case. Judge Glanville's extraditional misconduct cannot be ignored. Judge Glanville, lawyer Love, and lawyer Hilton have worked in lockstep to ensure that Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all crucial stages of this trial, and the federal constitution, as well as Article 1, Section 1, Paragraph 6 of the... Okay, I don't have to read that. Okay. This case can never return to constitutional normacy based solely upon the improper misconduct of lawyer Love, lawyer Hilton, and Judge Glanville. Any tragic conviction and sentence in this case would likely be reversed. Judge Glanville has made himself a necessary witness as his lawyer Love and lawyer Hilton. Should Judge Glanville not recuse, Mr. Williams will be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why lawyer Love, lawyer Hilton, and Judge Glanville were not just doing their jobs, but teaming up with a united front to convict Mr. Williams. Once armed with this evidence, the jurors can then properly determine what, if any, if this testimony and these facts will bear on their verdicts. Judge Glanville must be removed. Mr. Williams' motion to recuse, affidavit timely filed on June the 17th. Required Judge Glanville to answer a legal question as to whether the motion to recuse meets the threshold requirements. And then it goes here. This is simply a question of law. Judge Glanville acted way outside the parameters of the fair and impartial jurisdiction, denying Mr. Williams' motion, finding that it did not meet the simple threshold requirements. Okay. This June 18, 2024 ruling clearly shows the bias of Judge Glanville on Monday, July the 1st. Judge Glanville allowed undersigned counsel June the 17th motion to recuse to be forwarded to another court, while this shows that there is at least a reasonable appearance of impropriety by Judge Glanville. Judges shall disqualify themselves from any proceeding in which their impartiality might reasonably be questioned. Judge shall perform judicial duties without bias or prejudice, and shall not in the performance of judicial duties by words or conduct manifest bias or prejudice. Judges shall be faithful to the law and maintain professional confidence in it. And Judge Glanville has violated all of these crucial and worthy principles. Judge Glanville had the duty to act at all times in a manner that promotes public confidence in the impartiality of the judiciary. Judge Glanville has abrogated this duty, and hearing must be held to properly document this misconduct between lawyer Love, lawyer Hilton, and Judge Glanville. A full evidentiary hearing must be conducted where lawyer Love, lawyer Hilton, and Judge Glanville will be called by the undersigned counsel as witness to determine the nature and scope of their relationship and misconduct. Before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. Judge Glanville will be called as a witness by Mr. Williams. The law mandates that Judge Glanville be removed from presiding over Mr. Williams' case because he cannot be both a witness and judge in our lawful criminal justice system. Judge Glanville has given Lawyer Love, Lawyer Hilton, the Honorable Attorney Bumpus, and Witness Copeland legal advice. Mr. Williams' jury needs to understand who has been orchestrating this kangaroo court. Judge Glanville, Lawyer Hilton, and Lawyer Love should have separated and distinct roles in our criminal justice system. These distinctions between these roles have been washed away in Mr. Williams' case. When the judge instructs Mr. Williams' jury that by no common ruling or action taken by the trial court should the jury determine that the judge has any bias in favor of a party. This will be a dispute point of law. Mr. Williams will be calling Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jury must learn the conduct of these three lawyers when examining the evidence and evaluating the instructions. Judge Glanville is a necessary witness, Mr. Williams' trial, and must be recused. Lawyer Love and Hilton are necessary witnesses in the case and must be disqualified. As attested to in Exhibit A, Judge Glanville received extrajudicial information and also gave opinions and legal advice that include but are not limited to that Mr. Copeland went to prison for crimes committed on behalf of YSL. Uncontested fact in this trial. Mr. Williams and the other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. Mr. Copeland will be cross-examined on his other crime evidence because Mr. Williams and the co-indictees have far greater knowledge of Mr. Copeland and his background than others, and the like. By embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland. And Judge Glanville expressed the fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville be removed from this trial. Moreover, Judge Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as it's attached in Exhibit A. Let me move this up. Judge Glanville had an ethical duty to disqualify himself in this matter as he clearly has a personal bias and prejudice concerning Mr. Williams, the other co-indictees, Mr. Williams' counsel, and the other defense lawyers in the case. Judge Glanville has violated his oath by not volunteering disqualifying himself to avoid this impropriety and appearance of impropriety. Instead of Judge Glanville, Lawyer Love, and Lawyer Hilton have manufactured an unfair, unconstitutional broken trial and has caused Mr. Williams severe prejudice by incarcerating for over 2 years without bond, a laughable trial that has lasted entirely too long with the games played by Lawyer Love, Lawyer Hilton, and Judge Glanville. Judge Glanville must be removed. The instance discussed here, as well as in Exhibit A, represents more friction between zealous counsel and diligent jurists. Judge Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial toward Lawyer Love and Lawyer Hilton and the Fulton County District Attorney Office. Although proven, this honorable court needs not decide whether such bias or impropriety actually exists because Judge Glanville was ethical bound to disqualify himself whenever he impartially might reasonably be questioned, including instances where Judge Glanville's behavior could indict indicate that he has a personal bias or prejudice against a party or party lawyers. Judge Glanville's impartiality is more than unquestionable, and it is error to permit him to continue on Mr. Williams' trial. As shown herein and as attached affidavit, Judge Glanville is disqualified from any contact with this case moving forward based upon his bias against Mr. Williams and or his counsel, which stems in part from extrajudicial sources and results in opinions of the merits on some bias other than what Judge Glanville learned in his lawful participation of this case. As cited above, ex parte communications are presumptively harmful error. The state has the burden of rebutting the presumptions of harmful error, which it will not be able to do. Thus, any conviction and sentence will likely be reversed. Moreover, the issues surrounding this improper, secret, and coercive pressure campaign by Judge Glanville, Lawyer Love, and Lawyer Hilton will become evidence before the jury in order to attempt to explain this injustice to the trier of fact. Judge Glanville, Lawyer Love, and Lawyer Hilton will become witnesses. Mr. Williams is entitled to know these communications between Judge Glanville, Lawyer Love, Lawyer Hilton, and Mr. Copeland. Judge Glanville, Lawyer Hilton, and Lawyer Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory firm manner. Judge Glanville, Lawyer Hilton, and Lawyer Love have goaded Mr. Williams into moving for mistrial. All of the conduct and all the proceedings after Honorable Douglas Weinstein, as well as undersigned counsel, filed their motions to recuse and affidavits are deemed invalid and have no effect. Mr. Williams' constitutional and statutory rights to a speedy trial has been stomped on by Judge Glanville, as well as Mr. Williams' right to due process in a fair tribunal and the other constitutional rights stated herein and in the attached affidavit. This conduct must end, and all three of these lawyers must be disqualified from this case. Okay, I think it's saying the same thing. This is giving where the evidence is. Yeah, I think that's mainly it, y'all. Yeah, that's because I went over this and I think that's the main thing. Yeah, and then it's just gonna be the exhibit. Okay, here's Exhibit A. And what is in Exhibit A? Okay. It's just the affidavit. Okay. Let's go down. Let's see. And what is B? Okay, that's the ex parte. We read that. I'm gonna make sure I link this in there for the people that didn't hear, go over this. So if they want to read it, they can. I'll link it in this video. And I'm sorry, y'all. My phone keeps going off. I'm reading it. Let's see here. Just want to make sure we know. I remember that ex parte. I think that's what it took us an hour and a half to read that thing. There's a lot of pages. And some of that is missing from what he's saying. Okay, that's the end of that. Exhibit C. Okay, that was when he, that's the contempt, what he put after Steele. Yeah, I don't know. I'm gonna see how this goes. But they have been in cahoots. It is true. It's like he is on their side. And he was talking to the witness and telling the witness, yeah, he should have been doing. And he did talk to Bumpus and tell her how she's supposed to handle her witness. I mean, her client. And he didn't supposed to be doing it. Yeah. They're so correct in this. I do want to show you one one thing we're gonna get. It's one exhibit that you haven't seen. We're gonna get to it. Come on, y'all. And I'm gonna show that to you because it shows that Love, she lied in that ex parte about a Milnick. Okay, what's this? Okay, that's the appeal for the contempt. Okay, certification that they filed it. Okay, D is okay. That was the first when they first went to recuse him. Remember, we went over that too. But now, see what this is doing. He going not only for the judge. He wants Love and Hilton out of it. Oh, okay, that was the paperwork. That's still about Steele being contempt. And remember, they filed. They went after. Yeah, he should have known that wasn't gonna work. Okay, and that's showing the service of that. And okay, I think we get into what I want to show you. Now, what is E? That's still the contempt stuff. Okay, F. What is F? Okay, this is okay, that's the Kenneth Woody's to testify. That's that order. And what is Exhibit G? Okay, same, the recusal order. What is H? Okay, that's just okay. This is it. Exhibit I. I want to go over this with you guys real quick. Kenneth Copeland. This is the email. Remember, she in the ex parte, she was talking about, oh, he sent me an email telling me to F you and this and that. She didn't tell the whole email. This man told her. He contacted her. He found out she was talking to Woody, and he contacted her via email. Before they put Woody on that stand and told her that he was his attorney and that he's pleading the fifth, and they still put him on that stand. Okay, let's start here. Jonathan Milnick, June the 6th, to Love and to Hilton and to Steele and to Max. Subject, Kenneth Copeland. It says, good afternoon all. It has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney Office, nor any law enforcement officers. From this point forward, my client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Okay? Then Hilton answers him back, good afternoon. I hope all is well. In our conversation with Mr. Copeland, he advised that you were not his attorney. And she lying because we heard Whitney say, I told y'all he was my attorney. And then he said, and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communications. But y'all put him in the ex parte. Come on, these people here. But your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we were planning to pick him She left up. So please make sure that he is present so we do not have to take any further actions if he fails to appear for his subpoena. Okay. Then he answers her back. And he says, I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him, I also spoke with Don Gary extensively about Mr. Copeland when he was assigned to the case. And that was way before Love got on the case. And I spoke with Mrs. Love early in the process around the time jury selection was beginning. I have a plea with the judge, Capswell, tomorrow at 9, and I will come to the courtroom as soon as I'm done. So he's letting us know. They knew before they even started when they was picking juries, they knew before then. So, bull crap. You guys knew. But okay, you guys. That is it. Let me know what you think. Comment below. And state your opinions. And so on and so forth. If I missed something, let me know. But thank you for tuning in. And I appreciate every last one of you. Thank you, thank you, thank you.